Justice Jackson?
Yes, I am so glad for Justice Barrett's clarification, because I had the same thought about what you were arguing, and I'm glad that you clarified that your core point is that the Jingles test has to have a race-neutral baseline, or that the first step has to be race-neutral. And what I guess I'm a little confused about in light of that argument is why, given our normal assessment of the Constitution, why is it that you think that there's a 14th Amendment problem? And let me just clarify what I mean by that. I don't think we can assume that just because race is taken into account, that necessarily creates an equal protection problem, because I understood that we looked at the history and traditions of the Constitution, at what the framers and the founders thought about. And when I drilled down to that level of analysis, it became clear to me that the framers themselves adopted the Equal Protection Clause, the 14th Amendment, the 15th Amendment in a race-conscious way, that they were, in fact, trying to ensure that people who had been discriminated against, the freedmen, during the Reconstruction period, were actually brought equal to everyone else in the society. So I looked at the report that was submitted by the Joint Committee on Reconstruction, which drafted the 14th Amendment, and that report says that the entire point of the amendment was to secure rights of the freed former slaves. The legislator who introduced that amendment said that, quote, unless the Constitution should restrain them, those states will all, I fear, keep up this discrimination and crush to death the hated freedmen. That's not a race-neutral or race-blind idea in terms of the remedy. And even more than that, I don't think that the historical record establishes that the founders believed that race neutrality or race blindness was required, right? They drafted the Civil Rights Act of 1866, which specifically stated that citizens would have the same civil rights as enjoyed by white citizens. That's the point of that act, to make sure that the other citizens, the black citizens, would have the same as the white citizens. So they recognized that there was unequal treatment, that people based on their race were being treated unequally. And importantly, when there was a concern that the Civil Rights Act wouldn't have a constitutional foundation, that's when the 14th Amendment came into play. It was drafted to give a foundational, a constitutional foundation for a piece of legislation that was designed to make people who had less opportunity and less rights equal to white citizens. So with that as the framing in the background, I'm trying to understand your position that Section 2, which by its plain text is doing that same thing, is saying you need to identify people in this community who have less opportunity and less ability to participate and ensure that that's remedied, right? It's a race-conscious effort, as you have indicated. I'm trying to understand why that violates the 14th Amendment, given the history and background of the 14th Amendment.
The 14th Amendment is a prohibition on discriminatory state action. It is not an obligation to engage in affirmative discrimination in favor of some groups vis-a-vis others.
No, but as the record shows that the reason why the 14th Amendment was enacted was to give a constitutional foundation for that kind of effort, for the Civil Rights Act of 1866, which was doing what the Section 2 is doing here.
Right.
Which said by its terms that other citizens have to be made equal to white citizens, and people were concerned that that didn't have a constitutional basis, so they enacted the 14th Amendment.
Well, this court has specified, and I don't take the plaintiffs to be arguing that Shaw should be overruled or that Adirond should be overruled, that you have to, before the government goes forward and actually uses race to move people around into districts, for example, you have to have specific identified discrimination to justify that.
And isn't that the work of the jingles factors? That's what all the factors are trying to do.
Not if they're allowed to sacrifice our principles to come up with their maps. And if they're allowed to use race, this is the point I was making earlier, if they're allowed to use race to create their maps, then their maps can't show discrimination in our map. If you're trying to show that black Alabamians are being treated unequally through the 2021 plan, well, you need a plan that is neutral so it can be that control group and show you what's wrong with our plan. But if you're coming forward—
You're saying you need that as a constitutional matter because that's what the 14th Amendment requires?
Say as an evidentiary matter. So
we don't have a problem that the Constitution is creating. It's as an evidentiary matter, we have to have neutrality.
Well, no, Your Honor, if their evidence is bad, then you run the risk of replacing a neutral plan with a plan drawn on account of race, which would create its own Section 2 violations. I think a white Republican in Mobile, or a black Republican in Mobile for that matter, who's gerrymandered into the new District 2 and connected with people on the Georgia border would have a Section 2 claim himself because his vote has been abridged on account of race. So you can't read Section 2 that way. Equal openness and equal protection need to line up, and they don't under the plaintiff's approach. And we need a benchmark because obviously we need some clarity in this space. We've offered a benchmark. I've seen no benchmark in the briefs from the United States or the plaintiffs, and maybe they can illuminate that for us in just a moment.
Thank you, counsel.